And I think with that, we are ready to proceed now with the first case, which is Pat CRITELLI versus State of Florida.
May it please the Court. My name is Michael Becker. I'm Assistant Public Defender here in Daytona Beach, and I represent Pat CRITELLI, the appellant in this case. Mr. CRITELLI appeals the revocation of his probation and his sentence of 27 years in Department of Corrections. Just a little background I think is important. In 1989, appellant pled no contest to 4 charges. He was sentenced to 15 years in the Department of Corrections, followed by 10 years of probation. He was released from serving his sentence in 1995, August 1st, 1995, and began his probation. He transferred the probation to Colorado. In 2000, a violation of probation was filed. He was brought back to Florida, but it was determined that that was an improper violation of probation, and it was dismissed. He returned to Colorado. Subsequently, and what brings us here today, is on June 2nd, 1995, 2 months before the expiration of his probation, an affidavit was filed.
You said 1995?
I'm sorry, 2005. An affidavit was filed alleging a violation of probation. In particular, there were 3 conditions: a failure to submit to a genetic marker test, a failure to submit to a plethysmograph, in essence by rescinding the release of the results to the probation officer, and a failure to undergo a polygraph. There was a 4th allegation, but that apparently was abandoned, as the judge noted in its findings. Now, the important thing to start out with, none of these conditions were imposed judicially. These were conditions that were imposed by the Colorado probation officer.
Let me just, let's see if we can kind of cut to the chase. We agree with you that the 3 conditions that he allegedly violated were not contained in his original probation orders. I have 2 questions for you. Number 1, let's focus just for a moment on the application that he made to transfer his probation to Colorado, where he says, I understand that the supervision may be different than I would receive in Florida. I want to go. I urge the authorities to let me go. This will be a benefit to me and improve my opportunities. I accept such differences in the course and character of supervision as may be provided in the state that I consider the benefits. Now, one other line, in fairness to you, one other line that I think is relevant that you point out is failure to comply with the above was deemed a violation of the terms and conditions of supervision for which I may be returned to the state of Florida. All right. Now, is it your contention that the only penalty that could be imposed for a violation, let's assume for the sake of my discussion that a violation occurred. Is it your contention that the only penalty was booting him out of Colorado and sending him back to Florida?
If, as in this case, the violations are not contained in the Florida order.
Right, and I think we agree that they were not.
Yes, that's my contention.
Okay, so number 1, your contention is that the only penalty was to be returned to Florida. I guess my question would be, why shouldn't this be viewed as in essence, a voluntary modification of probation? I want to go out there. I'm willing to accept the conditions they impose. Please let me go.
I think if it would have been applied to a judge, perhaps that could have been done, but this wasn't. The case law in the state of Florida is replete with things that, only a judge can impose conditions of probation, and only a judge can modify a probation. We can't let other people, in particular, I want to draw this Court's attention to this former decision in Lane versus State, where a physician imposed a condition of a polygraph in the treatment for the sex offender probation. And this Court said, no, that was not a judicially imposed condition, so you can't violate him on that basis. Well, that was actually done in connection with the treatment that he was receiving.
But this is a little different, isn't it, Mr. Becker? I mean, he he sought the opportunity to go to another state, and as I read the documentation, it looks like he agreed to abide by their standard conditions or whatever within that state. And I don't know why a violation of those standard conditions, particularly if he agreed to do it, would not also violate his probation here.
Well, one, these were not standard conditions. That's our contention. These are not standard conditions. They're special conditions for sex offender treatment. And the reason for that, if you look at the...
Well, in Colorado, do they have to be imposed by a judge?
Well, interestingly enough, on page, I believe it's 7, I'm sorry, not 7, page 97 of the, I'm sorry, take that back, page 7 and 8 of the supplemental record, volume 5, and also page 5 and 6 of that supplemental record. They have the conditions for Colorado, and there is a place for a judge to sign them. The judge has not signed these conditions. So that is an indication to me that that's how they do it in Colorado, too.
What is the document you're looking at?
It is called the Additional Conditions of Supervision for Probation.
Okay.
And similar to our order of probation here.
How did that get applied in this case?
Well, that's where the conditions are listed, that he appropriated violate. Another reason why they're not standard conditions is that when he originally signed the agreement in 2001,
Well, let me back up for a second. Is there a statute that in Colorado that imposes standard conditions for this kind of probation?
There is a condition that there's a statute that provides for these conditions. They don't refer to them as standard conditions. They say additional conditions of supervision for sex offenders.
Is it mandatory?
No, they are not mandatory because when they check the ones that they want to do, and in fact, the original order, the genetic marker testing was checked.
Wait. I'm talking about the statute. Is the statute mandatory, or does the statute simply authorize the court?
The statute merely authorizes the imposition.
Let me ask you, was this issue raised at trial level?
Yes, I believe at one point in the hearing that the defense counsel even said, well, Judge, these were not judicially ordered conditions.
Judicially ordered in Florida or judicially ordered in Colorado?
He just said judicially ordered conditions.
Because without a specific objection, I mean, how do we know that there weren't copies signed by a judge, but if it wasn't brought to the court's attention?
Well, I believe it's incumbent upon the state to prove that he had noticed and they were properly imposed. I don't think the defendant bears the burden here. And in fact, well, even if he does, Mr. CRITELLI testified that I was never told I had to do the genetic marker test. You know, just as an
Becker,
example.
let me ask you to approach another issue. You and I think, would probably agree that Florida has adopted the Interstate Compact on Supervision, which I guess obviously Colorado has as well. And I looked at the statute, and the statute seems to suggest to me that, you know, we adopt the Uniform Compact and the rules that the Uniform, whatever the group is called, Uniform Interstate Commission for Adult Offender Supervision. We adopt their rules. I went back and I actually looked at those rules, and interestingly enough, they have a rule that deals with this. They have two rules. One says at the time of acceptance or during the term of supervision, the supervising authority in the receiving state, so in that case that could be Colorado, may impose a special condition on an offender transferred from the Interstate Compact if that special condition would have been imposed on the offender if the sentence had been imposed in the receiving state. The second rule that is applicable, I think, is for the purpose of revocation or other punitive action against an offender, the probation authority of a sending state shall give the same effect for a violation of a special condition or required imposed by a receiving state as if those conditions had been imposed by the sending state. Failure of an offender to comply with special conditions or requirements imposed by the receiving state shall form the basis of punitive action in the sending state notwithstanding the absence of such conditions in the original plan of supervision issued by the sending state. Now, I realize I've just confused you with a lot of sending and receiving, but the net result of that, it says, basically what it says, I think, is that if you violate a condition imposed on you by the receiving state, in this case Colorado, then you are in violation of your Florida probation as the sending state. And none of, interestingly enough, I don't see that the interstate compact or any of the rules was discussed either in the state's brief or your brief, but our research indicated that the interstate compact, which Florida has adopted, has a rule exactly on point that seems to cover this situation.
Well, I have two responses to it. First is, I believe the document that he signed may take precedence over that, because I think by their terms, Colorado maybe changed the terms of that. And, you know, I don't think it's fair to lead him to believe that this is what the penalty is going to be when in fact it's going to be something else. But my second point is the conditions that were imposed, I believe with the first provision that you read, they would be valid if they would have been imposed by the receiving state. We have no indication that they would have been imposed. They're not mandatory. They're not signed by a judge. We still have the law that, you know, they need to be judicially imposed, the conditions. The very fact that originally the genetic marker testing was not imposed, it was marked NA, indicates that they're not mandatory requirements.
But you still have the problem is that he agreed to do it. I mean, why isn't that just a stipulation to amend the probation?
Because I don't think that you can just stipulate to things that aren't legal.
There's nothing illegal about this.
Well, we have case law that suggests that you can't modify a probation unless there's been a violation or whatever. You can't add additional conditions after he's begun serving them, with a few exceptions within 60 days. If it's a mandatory condition, that can be added on.
You're just below 3 minutes if you want to hold on to a little time.
Okay. I will reserve the rest of my time. Thank you.
May it please the court, my name is Bridget Collins and I represent the state in this appeal.
I'm sorry, what's your last name?
Collins. First of all, Mr. CRITELLI agreed to the interstate compact agreement. He signed that agreement and said that he will abide by the rules, and he was aware that there might be changes in those rules of probation and the supervision that he would receive.
Let me ask you.
Yes.
Did the judge have Mr. CRITELLI come in front of him in Florida and say, you understand that, what it means if you sign this agreement, are you still willing to do so? And okay, now that I've heard you're fine with it, I'll approve this change to allow you to go to Colorado.
As far as I know, he did not come before a judge. He transferred immediately from prison. He signed the agreement and went straight to Colorado when his sentence was completed in 1995.
Right. And I know that there is a Florida Supreme Court case, Clark versus State, where even where you have a probationer who wants to change it and agrees to change, the probationer signs it, and the probation officer signs it, and it goes to the judge, and the judge signs it. I believe the Supreme Court has said that's not sufficient. The judge also has to have the defendant in front of him and approve it. Would Clark be applicable here, or is it different because it's an interstate compact case?
I believe that it is different because Clark and the other cases cited by the appellant are all regular probation cases. They do not implicate the interstate compact agreement. And in this case, clearly, he signed the agreement where I think it was Condition 6 of that interstate agreement that he signed said that if I violate these conditions, they will be deemed a violation for which I may be returned to Florida. And that is almost saying that he may not be even entitled to a hearing on that, which is not what we're setting
But
forth.
if you do that in a non-interstate compact case, would Clark versus State say that's not enough? Even though he signs a paper, says, I agree to this?
In a regular probation case, perhaps. However, we also have Peoples, which was cited in the appellee's brief, that says once you agree to the modification, you cannot complain about the conditions that were imposed on you. Here, he agreed to the interstate agreement, he agreed to be bound by Colorado's conditions of probation, and then when he decided he did not feel like following them, Mr. CRITELLI is now complaining.
How did he agree to these specific conditions? What was the mechanism?
Well, he agreed first by signing the agreement, and that he would be bound.
What did the agreement say?
Said that he would be bound by, and he was aware that there might
Bound
be
by,
the other condition, the conditions from the receiving state.
okay, and how was he advised of what those conditions are?
Those conditions are statutorily imposed in Colorado.
Well, Mr. Becker just got finished saying that they're statutorily authorized, but not necessarily imposed.
In his probation agreement from Colorado, the probation agreement that he signed in, the supervision agreement that he signed in Colorado, I should say, says that he was going to be put under sex offender intensive supervision probation, which Colorado has set forth what those conditions are.
Okay, now, the conditions apparently...
Let me correct you, because I'm looking at the document that I think you're making reference to, and where the very first paragraph says, you'll be supervised on sex offender intensive supervision probation pursuant to Colorado statute such and such, and it's marked NA, which I assume means not applicable.
Your Honor, that is actually the first probation supervision that he signed,
Okay.
which was back in 2001, I believe.
Okay, you're referring to the 2000.
Then on page 7, there's his new probation officer took over the case and indicated in the hearing that there was some trouble, that she had troubles with why that was marked NA and that it shouldn't have been. And so then she corrected everything.
Didn't he have a hearing before some judge, Judge Barton?
Yes.
And didn't, according to what I was looking through the record, at least Judge Barton, it seems to me at the very least there was a clear order from Judge Barton that he take a polygraph. And wasn't it the next incident, next polygraph that he showed up for, that he had his list of requests, demands, whatever you want to call them, a list of conditions that he wanted to impose on the polygraph
Correct.
examiner? The polygraph examiner told him to forget it.
That is correct.
So at least as to that condition, wasn't there an order from the judge after the first alleged violation of probation? Didn't they bring him before Barton and say, get this polygraph done?
I believe the order that you're speaking of came when he started contesting having to do the polygraph, and he filed an injunction to try and prevent him from having to take the polygraph. And then the judge did in fact say, no, you will take this polygraph. And then you're correct, he did go and say, well, I'll only take it if the polygrapher follows certain rules that I set forth. And it was during that time where he got upset and left and never took the polygraph on that day.
Well, I'm a little troubled by the notion that several years after he begins serving his probation in Colorado, a new probation officer decides to modify the conditions of probation. How does that come about?
I don't believe the new probation officer was modifying his conditions of
Well,
probation.
the probation officer said this NA is inappropriate, so we're going to erase NA.
But it wasn't a modification, because he should have been following that all along. That is what the conditions had said the whole time.
Well, don't you find it a little troubling that someone could change the rules in the middle of the game?
I don't believe the
A
rules.
non-judicial officer?
I don't believe the rules were changed in that instance. He knew what those conditions were. It appeared from what the second probation officer was saying was that his first probation officer wasn't really following through on things, and he was allowed to kind of coach through
Wait,
probation.
they had a handshake.
Pardon?
They had a handshake. I mean, the deal was, I'm going to go to Colorado, here's the conditions you're going to oppose, and there's a big NA on one of them, and then later on, Colorado says, no, that NA doesn't count anymore. Aren't you troubled by that?
I'm troubled by the fact that the probation officer said Mr. Critelli put the NA on his probation agreement, and that the probation officer didn't
Signed off
say
on it.
no.
Yeah,
Pardon?
signed off on it.
And that it was finally corrected by probation officer Hand, that he thinks he still didn't have to follow it because he'd gotten away with it before. It's a
Gotten away with it is hardly what I would call it. I mean, they had a written a document that described what he was supposed to do, and then they added a non-judicial officer added another condition.
Well, even with the NAs marked on that first agreement, there was testimony from the first probation officer who she thought that he had taken a DNA test, even though he hadn't. So that alone would also indicate to me that he was aware he had to take a DNA test way long ago.
Where does it say that? Where is there any written indication that he was required to take a DNA test before the NA was erased?
When he was told by his probation officer. When he read that and he alone signed off the NA on himself.
Mhm.
That is when he knew he had to take a DNA test. He was trying to get around it. And he was successful in avoiding it for a certain amount of time.
I mean, I must tell you, I'm not terribly convinced by that argument. I mean, it seems to me that they had a single piece of paper between them, and the one that came out of that meeting was the one that had NA on it, however it got there.
Well, there wasn't just a single piece of paper. There was that. There was also the original interstate compact agreement and his original order of probation, which told...
Did any of those say anything about a DNA test?
No, not the original ones, no. But
So what other violations of probation were there besides not taking the DNA? Because frankly, you're not selling me on that one.
besides the DNA test, he was also instructed to take the polygraph test, which he did not. And
He was told by a judge to do that,
he was told by a judge, yes, and his
and he
probation
did
officer.
not do it.
Well, and that condition of a polygraph, looking back on the 2001 order, was in the original order. I agree the genetic marker testing was not, but the polygraph was.
Correct.
And then when he squawked about that, and he filed an injunction, the judge said, no soap, take the test.
Correct.
Did he take it after that?
He did, no, he did, well, he took,
Ever?
he did take one after that, after he refused to take it on that particular day, and he then went back and found, I believe, another polygraph examiner that he took the test with. But on that day when he was instructed to, he did not take the test.
And is that a violation?
Yes, it is.
Is it a substantial violation?
Yes, I believe it is.
Is it a willful violation?
It is definitely a willful violation. He went in there and walked out without taking it.
What's the definition of a substantial violation if he took it later?
If he,
If he eventually took the test, why would it be substantial that he didn't take it the first time?
because he was instructed to take it on that day, and it was a way for him to get around it. His purpose in,
Why didn't they pack him up and ship him back to Florida at that point?
because they still had to file the violation on that incident, and they had to have the probable cause hearing. Between his violation and his probable cause hearing is when he took the second polygraph test, the last polygraph test, which is almost, I realize I messed up, I'm going to try and correct it quickly so maybe I won't get in as much trouble. And that's what it appears that he was trying to do, and that does not, correcting the violation at a later point doesn't make it not a willful and substantial violation.
What else do you have?
We
Other
also have
violations?
he rescinded his permission, he rescinded permission to send his results for the plasmograph, otherwise known as the PPG test. He rescinded his results from the examiner so that his probation officer would not get the results. Counsel points out that, yes, he did submit the results later, but that's not what probation says. The condition of probation was to release the results to his probation officer. That alone is also a willful and substantial violation of his probation.
And this is in his last year of probation?
It is in his last year.
So he served how many years in prison?
He served 6 years in prison, I believe, and then he was on his 10th year of probation.
And in the last gasping moments of probation, he manages to pick up 3 violations?
No, it appears from the record, from the testimony of Lucia Hand, the Colorado probation officer, that he was doing things throughout that they probably should have violated him on before, but they chose not to for some reason. I can't speak for Colorado and why they chose to do that, but it appears that his previous probation officer was allowing him to skate. And when the new probation officer took over his case, when his first probation officer left the office, she began making him follow the actual rules of probation, and he doesn't seem to have liked that. And that is why he violated just towards the end. And simply because it's at the end of his probation doesn't mean it's not a willful and substantial violation that should send him back to jail.
How do we know that his first probation officer was allowing him to skate?
Through the testimony of the probable cause hearing in Colorado, in that transcript, there's testimony that it appears that he was not allowed to do, or he was allowed to do things that he shouldn't have been, such as being with children. And while that's not an allegation in this, and he was not found to have violated his probation because of that, that is what she was speaking of. Furthermore, or lastly, I should say, Mr. CRITELLI agreed to this transfer. Mr. CRITELLI agreed that he would follow the conditions of probation set forth in Colorado. These were standard conditions in Colorado that were statutorily imposed for sex offenders. Therefore, he was on constructive notice, and according to the case cited by Appellee Williams, when you're on constructive notice of the condition, you have notice and you could be found in violation of that condition. If there are no further questions, the state would respectfully request that this honorable court upheld the ruling of this lower court.
Thank you, ma'am.
Thank you.
Mr. Becker, let me ask you something. If Mr. CRITELLI signs this form, says, I want to go to Colorado, and I agree to follow all the conditions Colorado imposes, and he gets to Colorado, they've added 10 obnoxious conditions, and he says, you know what, I didn't know what I was getting into, I'm unwilling to follow these conditions. Is the remedy there then to send him back to Florida?
Yes.
All right. Now, on the polygraph issue, he goes in front of a judge. The judge says, you will take the polygraph. Is it his obligation at that time, if he objects to that polygraph condition, to say, no, Judge, I don't want to modify my probation with that condition, I'm willing to go back to Florida?
I think if he never wants to take a polygraph, yes, it is.
All right. Well, if the
That's
judge,
the case here.
so he goes in front of the judge, which may solve the Clark versus state issue on that one violation. And the judge tells him, and he doesn't say, no, I don't want to comply with that, send me back. Is he then required to take the polygraph? Is that now a valid condition of probation?
Arguably, and I think he did take a polygraph after that.
Well, wasn't the testimony at the first time that he goes in, he makes his demands, and the polygraph, the person says no, and then he says, I won't take the test, even though he testified I would have, but it wasn't testimony as he told them I'm not going to?
I think, though, you have to look at that in context with why he did that. He had had problems with this polygraph examiner before, with what he believed was misinterpretation.
Well, isn't his remedy then to go to the judge and ask the judge to switch polygraph persons or make
Well, he
his
went to the
request?
probation officer to ask to switch polygraph.
But until the judge switches it, doesn't he have to?
Well, I think the operator is not something that the judge has to do. I don't think the judge says you must take a polygraph with this particular operator.
But if he's objecting to that particular polygraph operator, I mean, probation has the right to pick that person, correct?
Yes.
So if he wants to change it, isn't his remedy to ask the judge to change it and list the grounds he did rather than decide on his own that that polygraph operator is unacceptable?
Again, there's not an easy answer to this, I don't think, because I think you need to look at what his demands were. These were not horrible, horrible demands. He was asking, report all the questions. Take my answers down verbatim. Don't paraphrase me. To me, that's not even demand. That's just common sense that tells you this is what they ought to be doing.
Well, the polygraph operator, wasn't there testimony that makes the polygraph less effective if they release the control questions beforehand?
Well, he didn't want to be beforehand necessarily.
Right, but if he knows the ones he used at that time,
Well, but he's going to know them the next time anyway. If he takes them, he can remember them. So the fact that he wanted them, written down, and he didn't say release them to me, he said release them to when you send these results out. He wanted to.
Counsel, you've exhausted your time. Thank you so much.
thank you, Mr. Mayor.
Thank you.